Welcome everyone to Stanford Center for International Security and Cooperation and our weekly research seminar. My name is Harold Trinkunas. I'm the Deputy Director here. It's a great pleasure for me to host Dr. Jennifer Welsh. She is a professor, global governance and security at McGill University, as well as the Canada 150 Research Chair. She previously was a professor at the European University Institute and at the University of Oxford. She also has policy experience, always something that is valued here at CSAC, where we do a combination of sort of policy research and traditional academic research. From 2013 to 2016, she served as special advisor to the UN Secretary General Ban Ki-moon on responsibility to protect. And in fact, this is an issue near and dear to our heart, and at the core, I think, in many ways, of our new book project, which is what she'll be speaking to us about today. She'll be speaking on sovereignty as responsibility. In this book project, she's taking a step back to look at the current debate about sovereignty and post-Westphalian sovereignty in the wake of the Cold War. And in particular today, focusing in her talk on responsibility to protect. So we're looking very much forward to hearing from Professor Welsh. Professor Welsh, welcome, and I'll turn the seminar over to you.
Thank you very much. And I joke with Harold to start, his beautiful Stanford background. It's snowing outside my window in Montreal today. So I wish even more that I was with you at Stanford. And I'm really glad to have the opportunity to talk about this book, which I've actually been working on for a long time. I put it away for a number of years when I was working very actively in the policy world on responsibility to protect. And in the last year and a half, I've come back to it. So what I want to do is give you a sense of the background to this project, the goals and the structure of the book, and then try to illustrate some of the arguments through the notion of the responsibility to protect. So the context for the book for me has been a broader debate that's been occurring within the literature, but also in the policy world about the standing and nature of sovereignty. On the one hand, claims about a new understanding or new meaning of sovereignty in the 2000s. And on the other hand, more recent claims about the resurgence of sovereignty, or even in the work of scholars like Roland Paris, the idea that we have states practicing different conceptions of sovereignty. But what I ask in the book is, even if we do see a resurgence of Westphalian sovereignty, are we really returning to a Westphalian world? So that's one context. The other is to try to step back from a number of more specific articles and pieces I've published over the last few years on responsibility to protect in particular, using sort of middle range theories about norms and norm contestation, and to try to put that in this larger context. So in this sense, it's a big book. Those are always a little dangerous. But in any event, that's the context for which I wanted to present my comments today. So the central goal of the book is to analyze the rise and the application, but also the contestation of the idea of sovereignty as responsibility that was developed and diffused in the late 90s and 2000s. And I ask three questions in the book that partly structure the nature of the book. The first is how novel this liberal post-Cold War understanding of sovereignty really was. Secondly, to analyze to what degree state practice reflected that understanding. And then lastly, I want to, in the very end of the book, engage in a normative analysis of whether it's desirable to understand sovereignty as conditioned upon responsibility. So the book is organized around those themes. In the first part, I engage in more conceptual and historical work. I lay out what I'm describing as the liberal understanding of sovereignty as responsibility. And I claim here that it has three components. It tends to involve a sense of movement or progress, that we have an understanding of sovereignty after the end of the Cold War that differs from the absolutist conception, which centered around a hard interpretation of the principle of non-intervention that allegedly prevailed during the Cold War, and that now we're in a moment different from that. Secondly, the understanding was based and drawn from social contract theory. So the idea that states can lose rights of sovereignty on the basis of somehow breaking a contract with their populations. But lastly, and this is pretty important for the argument that I try to make in the book, it also identifies a source of authority that sits outside the state that can, in a sense, as part of the normative framework that's being forwarded, capture the transfer of sovereignty from states and exercise a form of judgment on behalf of the international community. So the next two chapters, chapters 2 and 3, look at how novel that understanding of sovereignty as responsibility really is. And so in chapter 2, I look at understandings of sovereignty forwarded by Baudin and Hobbes. And I argue there that even when it's understood in absolutist terms, sovereignty was never intended to be completely unconditional. Certain capacities and obligations have always been part of the claim to authority within territorial boundaries. But early theorists of sovereignty did maintain that sovereign authority was unlimited, in that no coherent or centralized external authority could rival or compromise it. So that's the argument I make there in that chapter. And in that chapter, I also challenge the view put forward by some IR scholars that the principle of non-intervention was a later development and was not at the core of original formulations of sovereignty. I make a specific claim where I put that claim into question. In chapter 3, I continue this discussion of how novel sovereignty as responsibility is by showing that the understanding of sovereignty that we really work with today in the modern international system, which I would argue is a 19th century development, is less the version that's promoted by the absolutists and more the version we find inscribed in the writings of positivist international lawyers in the 18th and 19th centuries that really pivot around the idea of sovereign equality. And this positive international law gives rise to a system that formally acknowledged internal supremacy and external autonomy, but it also legitimized sovereign rights as the protective shell for self-determining political communities. Now, I also, and this is the theme of chapter 3, I show very clearly that this framework was aspirational and that it was geographically circumscribed. Great power and civilizational hierarchies compromised those original ideals in the 19th century. And so we can see both through the practices of humanitarian intervention and state recognition in the 19th century in particular, that certain criteria, civilizational criteria, were attached to the treatment of particular entities and the recognition of new states. But in doing that, I make one of the claims that underpins the book, and that is that contemporary liberals too often take as their reference point an understanding of sovereignty that dominated in the Cold War period, without looking back to examine sovereignty's longer trajectory. So that's part one of the book. Part two is really the meat of the book, and I'm going to talk more about it today, is the empirical part of the book, where I really seek to determine how member states of contemporary international society have understood sovereignty through an examination of their practice. And in doing that, I question, or probably more accurately, temper some of the accounts about the transformative impact of liberal ideas. And I argue that a conditional understanding of sovereignty was not necessarily shared or practiced across international society, even during the height of the liberal moment, the liberal internationalism of the post-Cold War period. And so my assessment, in a sense, is a challenge both to some of the proponents of sovereignty as responsibility, but also to some of the fiercest critics of that notion, who I think overstate its negative effects. And in doing that, I examine two kinds of practice in the book. The first we might think of is a negative practice, how states lose the rights of sovereignty. And this is the more familiar sense of sovereignty as responsibility, as manifest through the practice of humanitarian intervention and the principle of responsibility to protect. So states somehow forfeit their right of non-intervention and become subject to coercion if they do not fulfill their sovereign responsibilities to protect their citizens. But it's also the case that we can see sovereignty as responsibility being asserted in a more positive sense through the practice of state recognition, that somehow entities are constituted as sovereign states or given international personality on the basis of whether or not they fulfill certain substantive criteria. Now, the analysis in this section of the book questions the extent of some liberal claims and reveals that these negative and positive practices in the post-Cold War period don't necessarily accord with a conditional reading of sovereignty or the recognition of a legitimate international authority to whom responsibility could somehow be transferred. And in doing that, I spend a lot of time empirically trying to demonstrate how the liberal understanding of sovereignty has been contested. I draw on recent approaches from the international relations literature on norms to do that. And I show that in some cases, the opposition to sovereignty as responsibility has been more indirect, expressed through attempts to reshape more assertive liberal understandings with a particular interpretation of state responsibility. But in other instances, the opposition has been more frontal, if you will, or fundamental, as it was, for example, in Russian and Chinese critiques of the NATO intervention in Kosovo and opposition to international action in Syria. And so I acknowledge that the capacity to contest sovereignty as responsibility has been shaped in part by the configuration of power in the international system. So certainly while in the late 90s and early 2000s, Western states enjoyed a more privileged power position, by the late 2010s and arguably before, those contesting sovereignty as responsibility had new possibilities to do so. But I also argue that contestation has been shaped by other competing normative ideas. Chief among those, the powerful principles of self-determination and the right of national approaches to development. And so as part of my discussion about how sovereignty as responsibility is being contested, I concentrate particularly on how China has used those normative resources in its attempt to reshape more assertive liberal ideas of sovereignty and international order. The last part of the book, which I'm not going to say that much about today, is more a normative evaluation of sovereignty as responsibility. Is it desirable for us to connect sovereignty to responsibility in such a direct way? And I make the case at the end of the book for a more deferential kind of liberalism that re-elevates some of what I would argue are also liberal principles that underpinned late 18th century and 19th century conceptions of international order around notions of self-determination and sovereign equality. And I suggest that it's not a bad resting place for a world in which there are attempts on the part of more powerful states to exercise a more extra legal form of sovereignty. So I want to spend the rest of my time illustrating some of the arguments with respect to the principle of the responsibility to protect. And this is chapter 5, which I circulated to those of you who were interested, along with the introduction to the book. Now, responsibility to protect, as some of you will know, was really designed as an alternative to humanitarian intervention. It was hoped it would avoid the intense controversy that had accompanied that practice from as early as the 19th century, as I show in the book. And so the aim of the principle was to galvanize attention around the need to prevent the very kind of humanitarian emergencies that in the past had given rise to debates about the duty or right to intervene. And it was also advocated as a political rather than legal principle. And I can say more about this in Q&A if you're interested. It was argued by advocates of responsibility to protect that what was needed was not more law. We had appropriate legal structures in terms of the Genocide Convention, the Geneva Conventions, but what we needed was greater compliance with states' existing legal commitments. And I've argued elsewhere around what the goals of responsibility to protect were as a political principle. But it was also premised on a more ambitious conceptual shift in the meaning of sovereignty itself. The idea of sovereignty as responsibility, which claimed that states' internal as well as external behavior would determine their legitimate standing in international society, and that the international community could act to ensure that states lived up to the expectation of good international citizenship. So to put it another way, for those actors promoting responsibility to protect, the development and diffusion of this principle was a calculated wager, that by building and invoking a sense of common responsibility, more concerted efforts to prevent and respond to atrocity crimes would be undertaken. However, what I show in chapter 5, and I'm going to go through this in a little bit more detail before we open up to Q&A, is that the form of institutionalization of responsibility to protect that was achieved in 2005 in the World Summit Outcome document really evinced some forms of opposition to the idea of sovereignty as responsibility. I also suggest in the chapter that the principle itself is open and vulnerable to contestation because of the type of norm that it is and because of its three-pillar structure. And I also show that ongoing contestation of responsibility to protect has shaped its meaning in ways that reinforce existing structures of collective security and that seek to create strong, capable states. So let me go into those points in a little bit more detail. And I apologize for all the text on the left. I wanted to give those of you that have never seen paragraph 139 of the Summit Outcome document a clear sense of what was actually agreed to by states in 2005. So the moment of institutionalization, I think, is important to reflect on for a few reasons. Firstly, the appearance of R2P in the summit outcome document, I think we can see only as partly a result of normative momentum. It was also a product of exogenous factors that flowed from the Iraq War and its fallout, and particularly the larger project for UN reform that was launched by the Iraq War and its aftermath. And there are some in the audience that I know are very familiar with that period, so I won't go into it in any more detail. And it's also clear that negotiations began with a rift between supporters and detractors. I just want to say in passing that that split was not the regular North-South split that you might anticipate. There were states from Latin America, from Africa, that were very supportive of responsibility to protect. There were more a set of states in the Middle East and South Asia that were the most prominent opponents. And the worries that were being raised here will be familiar to you. Concerns about how responsibility to protect might erode the principle of non-intervention, worries about potential abuse of the principle by the great powers, but also, and this is a theme I think that is less discussed, and it became more important as the negotiations over this article progressed, is that a number of states were emphasizing that countries in crisis needed international assistance, not coercive intervention, and that should be the focus of the responsibility to protect in the way that it's articulated. And you can certainly see that at the end of the paragraph that I've produced for you here. If you analyze the diplomacy around the summit outcome document, you see very clearly, there's a lot of work that's been published on this by a variety of scholars, that the appearance of R2P in the summit outcome document was not a given, and it reflected a particular framing of responsibility to protect that in many ways was non-transformational. So while you had after 2005, after the ink was dry, a number of actors saying this is a watershed moment, even some scholars saying it's like a Magna Carta moment. In many ways, states agreed to paragraph 139 precisely because it was not seen as transformational. And there are a few things I want to emphasize here. Firstly, responsibility to protect was not located in the summit outcome document under a discussion of collective security. It was included instead under a section on human rights. And I read that, and this is just my interpretation, as some limitation or some degree of discomfort with including it as part of a regular discussion of the situations in which force could legitimately be used by members of international society. Secondly, it famously called for further discussion of the principle in the General Assembly. I have the battle scars of that further discussion. I presided over that discussion 4 times as special advisor on responsibility to protect. A fascinating experience to hear states' views. But I think there's a number of ways as well in which paragraph 139 reflects some important features of the principle. Firstly, it re-emphasizes in the paragraph prior to that the primary responsibility of states to protect their populations. Secondly, it affirms the need to assist states under stress before crises develop. Thirdly, it declares a preparedness to take collective action in situations where states are manifestly failing to protect their populations, not an international responsibility. And you can see, if you look through successive drafts of the summit outcome document paragraphs, the notion of a collective international responsibility is gradually stripped out of the document. including by, among others, John Bolton, who was the ambassador to the United Nations for the United States at that time. Fourthly, and this is interesting for other parts of the book, it uses the language of manifest failure rather than the notion of unwilling and unable. And you see the latter language in a number of different contexts. You see it, for example, in the context of discussions around drone strikes, where states are deemed to be unwilling or unable to capture terrorists, and therefore their territory can be made vulnerable to extraterritorial attacks. Unwilling and unable is a phrase that's often used to describe situations in which state sovereignty will be overridden. And you can see again in the negotiating history, states being very uncomfortable with the idea that unwillingness or inability will somehow be interpreted subjectively by members of the international community. And so instead, they opted for this notion of manifest failure. And then lastly, the summit outcome document uses, for better or for worse, the existing collective security provisions of the UN Charter. And what do I mean by that? I mean that it is the Security Council that is the agent that must authorize the use of any coercive means in the service of the responsibility to protect. And I say for better or for worse, because you can see in the negotiation, states were very aware of the possibility of Security Council paralysis. But there was a cost-benefit analysis done by a number of them as to whether it was worse to try to have more ambiguous wording about the authorization, or whether in fact that was necessary to constrain what was seen as a greater evil to Security Council paralysis. So where have we been in terms of implementation and contestation since 2005? And Harold, I'll just take a few more minutes to go through this before we open up to Q&A. So you'll see in the chapter I circulated that there's been enormous progress on a declarative and institutional level with respect to the responsibility to protect. And I in no way want to take away from that progress. All of the intergovernmental bodies of the United Nations now regularly invoke and discuss the principle. There have also been institutional developments within a large number of member states within the UN system, also within the European Union, the African Union, the Organization of American States, and particularly within the realm of atrocity crime prevention in terms of analytical toolkits for risk factors, diplomatic procedures and ideas. So all of this has been extremely important and material, I would argue. But we can see contestation along a few dimensions. And those of you who have looked at the IR literature on norms and norm contestation over the last 5 years will see a couple of ways of theorizing about contestation that I reference in the chapter. First, there's a distinction that's drawn between applicatory and justificatory contestation with respect to norms. And what this means is that states and other actors can either contest whether or not a norm applies in a particular situation, or more fundamentally, they can argue as to whether a norm is legitimate and warranted in and of itself. And so the second kind of contestation is much more troubling for a norm. I think we can see both types of contestation with respect to R2P. Secondly, we can think about contestation as being either discursive or behavioral. So clearly in the way that states justify their behavior or the way in which they contest interpretations of the responsibility to protect in their statements is important. But we can also see contestation behaviorally in terms of the way they respond to particular kinds of situations. And again, I showcase some of those in the chapter. We see both kinds of contestation with respect to the responsibility to protect. And I think there are three reasons, at least, why we've seen this contestation. The first is that R2P is a directive norm. It seeks to bring about a state of affairs, the protection of populations, rather than prescribing a particular behavior, as it with some of the norms, for example, against torture, against whaling. It is much more about bringing about a certain outcome. And secondly, it's a complex norm. It rests on, as some of you will know, three pillars. First of all, a state's primary responsibility to protect its population. Secondly, the responsibility of the international community to assist states in fulfilling their responsibilities. And then lastly, a responsibility on the part of the international community to act when states are manifestly failing. But what that means, according to some, is that a breach of one component is meant to act as a trigger for the others. And as you can imagine, part of the contestation surrounds whether that trigger has actually been activated in all cases. And then finally, and I won't go into this because I've written about this in an article that came out in JOGS a couple of years ago, R2P primarily asserts what I would call a duty of conduct for its third pillar. It asks the international community to consider whether a situation features atrocity crimes and to deliberate on the appropriate response. But it does not dictate what that response should be. So as I show in the chapter, and I'll end here, I think we're seeing four kinds of contestation, which also give rise to questions in my mind about the degree to which a more transformative conception of sovereignty as responsibility is being practiced or was practiced in international society. So the first, of course, is contestation over the relationship between the pillars, a kind of sequencing. Should we not allow states themselves the opportunity to protect their populations in ways that they see fit before the international community offers its assistance or indeed intervenes? And there's a few concrete cases in which we can see this. Secondly, what cases of concern are R2P cases? And to me, this is among the most interesting changes of the past 5 or 6 years. That we had a discourse for a number of years where atrocity crimes were deemed to be matters by their very nature, matters of international concern, which legitimated international discussion and involvement. But what we're seeing in a number of cases now is a description of violence going on in states, not in the language of atrocity crimes, but rather this is regular political or intercommunal violence that does not rise to the level of a matter of international concern. We can see this in Burundi. We can see this to a certain extent in Myanmar and other cases. Thirdly, we've seen contestation of the nature and scope of the international community's role under the third pillar. This, of course, centers on the controversy raised over the Libya intervention and its aftermath, so I won't say anything further. And then lastly, and this is where I think China's role has been particularly interesting when you look at its engagement on responsibility to protect in the General Assembly and elsewhere, we've seen a move from a more people-centered idea of responsibility to protect as essentially instantiating human security to one where there's an emphasis on the responsibility to protect, assisting states to build up their state capacity. That the role of the international community is to assist states in increasing their strength, and that that assistance should be demand driven and not supply driven. That states should ask for that assistance and not have it necessarily supplied. So I hope that's given you a sense of what I'm trying to do in the book and with what I'm trying to argue about responsibility to protect in particular. And I'd be delighted to take any questions that you might have.
Thank you very much, Professor Welsh. We have time now for some Q&A. Please go ahead and use the Q&A function in Zoom to write out your question, and I will go ahead and read those, maybe combine them in some instances. One of the questions that came up, and you touched on it very briefly, but I don't know if you wanted to go into more deeply, was R2P in the 2011 intervention in Libya. And I'm thinking here as well, to expand on the question, some of the critiques that came out of that, of the R2P concept, but also alternatives such as Brazil's proposal for RWP. And maybe if you could just go into a little more depth, your thoughts on that episode and how that shaped the R2P debate going forward.
Sure. And I will say that this, I came into my role as special advisor on the responsibility to protect in July of 2013. And much of the discussion at the time was around how we have moved, we're able to move beyond the Libya intervention. That yes, it was controversial, but the responsibility to protect agenda is wider and deeper than the use of military force. And I do agree with that, and I can elaborate on ways in which I think that that has demonstrably been the case. But everything I saw led me to believe that the fallout from that intervention did have very significant impacts. So I talk in the chapter about an attempt to have a new General Assembly resolution on the responsibility to protect in 2015. A new consensus resolution, there hadn't been one since 2009. And those efforts fell apart in many ways as a result of discord over the Libya intervention, but also over the Brazilian proposal. Because I think the Brazilian proposal had two elements, one of which had a very positive impact and one of which led to more contestation. So the positive impact was that it stressed a great deal the idea of prevention and the need for states to act earlier, and for the Security Council in particular to take a role in prevention in a way that it has rhetorically said it will, but has very rarely done. And so it did lead, I think, to, even within the UN system, but elsewhere, more concerted efforts to really operationalize prevention. But the other really challenging piece of the Brazilian proposal was this idea that those who use force on behalf of the council in order to implement a protective mandate must be accountable to the council, and that they must come back somehow. There must be a review. And of course, underscoring that is this concern with mission creep and mandate expansion. And what was interesting to me was the degree to which that idea had significant support, but it was the P3 that were resistant. It was the United States, it was France, and the UK. And that resistance was reflected in opposition to any idea that the councils should be accountable to anyone, but also that it extends to this idea that the council could also be in any respect accountable to the General Assembly, or to have if you will, the division of power among UN entities somehow shift as a result of principles like the responsibility to protect.
Thank you. So the next question is from Beth Van Schack. She says, Jennifer, thanks for a terrific presentation. I look forward to reading the book. I would be interested in your thoughts on whether and how the United States has accepted the R2P framework. I read President Obama's national security strategy as being supportive, but I've heard others argue that the US has never accepted the concept.
Yeah, that's a really interesting question. So I read John Bolton's intervention in 2005. Sorry, and I don't mean military intervention. I mean his intervention in the negotiations of the summit outcome document as being in part, of course, difficult and obstructionist, but in another sense, reflective of the United States' own political culture with respect to the notion of responsibility. That I don't need to tell this audience, you know better than I do, that you go back to the 1920s and the League of Nations, the idea that there is any entity that will a priori define when the United States can use force is an idea to which there's great resistance. So I think there has been difficulty in the United States with the concept of responsibility because of the idea of it tying your hands in advance for some time. Now, that being said, if you look at how the United States embraced genocide and atrocity prevention, institutionally, it did a great deal. And that lived on in the Trump administration in different forms. And I understand, but I need to learn more, that it's being reshaped in the Biden administration. So institutionally, the United States did some of the most interesting things to build an atrocity prevention board and to share that expertise and methodology with other states. And so there was a grouping, and it still exists, of states that regularly get together and talk about analytical tools and diplomatic tools to enhance atrocity prevention. So I think it is a mixed answer. I think where, and I need to tread a little carefully here, I think where, if I can be honest, where I was disappointed as special advisor was that in the years where I played the role, one of the steps we tried to take, and I think it was relatively successful, but you can take what I say with a grain of salt, was we tried to move the responsibility to protect out of New York to regional organizations, but also to Geneva. Because if you take prevention seriously, the idea here is that certain types of human rights violations and developments are early signs of atrocity crime dynamics. And so the treaty bodies, but also the special procedures mandates in Geneva are extremely important. And I think the United States was less, I don't want to say supportive, but it was less active in our moves to really build up discussion of the responsibility to protect in that format. And I'd like to understand the reasons for that better. But I think it's part of the political culture of the US. I didn't encounter hostility. And there was also a sense, also with the UK, that there was a sensitivity to the degree to which responsibility to protect would be seen as a great power enterprise. And therefore that states such as the US and the UK should not always be out in front in terms of diplomatic advocacy.
Thanks. Let me take a question now from one of our postdocs, Lindsay Hundley. She says, thank you for a fascinating talk. As you discussed, many opponents of R2P criticize the principle as inviting states, and strong states in particular, to overthrow governments they dislike. But it also appears that these same opponents sometimes interpret R2P to justify helping to prop up governments that they like against domestic opponents. How do you think this latter interpretation will influence whether R2P remains an important component of sovereignty moving forward?
I'd love to ask you who you have in mind. um, I think I can guess. I actually think what's more interesting, even, I'm not saying your question's not interesting. I mean, there are those cases in which states that some promoters of R2P believe need to be strong states for geostrategic reasons. They are given a pass with respect to what may be occurring within their sovereign jurisdictions. I think I can think of examples of that. I mean, I think certainly the end of the Sri Lankan War in 2009 and 10, which I think is referenced in the chapter I sent you. If not, it is elsewhere. You know, what was extremely interesting about that case was that Sri Lanka's discourse of counterterrorism really avoided any serious discussion within the Security Council or elsewhere about what was happening to civilians on the ground at the end of that conflict. I think, but I want to get to the second point I wanted to make about your question. Where I think it's even more interesting and problematic is in cases where Western states are trying to support states that are democratizing. So if I take the example of Myanmar, which in 2015 was very much on everyone's radar, working in the atrocity prevention community in terms of having very clear risk factors that suggested that there could be large scale and targeted violence. And the degree to which preventive action was extremely difficult, not just in states like the United States or the UK or others who wanted to be very supportive of Aung San Suu Kyi, but even I would argue within the United Nations itself, which had a very bifurcated approach. On the one hand, it wanted to support its political transformation, and on the other hand, there were huge concerns being expressed about the Rohingya population. And I do agree with the tenor of your question, that this does give or create, I think, opportunities for contestation that make it harder to take effective action on atrocity crime prevention, even at a late stage, not to mention at an earlier stage. So I would encourage us to think about a variety of contexts and not just that one that is very clear that you raise, where there is a strong state with strategic value, which is shielded from critique by other states in terms of its treatment of particular identity groups or populations.
Thanks. And in fact, there had been some questions about Myanmar in the Q&A, which I think you've touched on in your answer here. So let me go to a question by Norman Neymark, and then I might come back and see if you have more to say on Myanmar and also China in the situation with the Uyghurs was also raised. So from Norman Neymark, he asks, what were the major differences between the original R2P document authored by Gareth Jones and al. In the UN 2005 document? That might tell us something about how the doctrine came about in the first place and how issues of UN reform might have changed that document.
Yeah, it's a great question. And I touch upon this a little bit in the book. It's also been written about by Tom Weiss, to a certain extent by Alex Bellamy and the late Ed Luck. There's a few differences that I would highlight, some very positive and some more mixed. So I think two positive things that were different from the original ICISS conceptualization, ICISS, the International Commission on Intervention in State Sovereignty. One is that that first articulation had a very general rubric for the applicability of R2P. It talked about large-scale loss of life, real or apprehended. And that was incredibly broad. It didn't really answer the question of what kinds of humanitarian or human rights emergencies were really within the realm of this principle. And so what the 2005 Summit Outcome document did was specify that in terms of 4 specific crimes. My view, some disagree with me, was that was a strength, because international crimes, by their very definition, are matters of international concern. We don't have a huge number of international crimes. By my count, we have 4. Genocide, crimes against humanity, war crimes, and aggression. Other crimes like piracy, it's more debatable. We have transnational crimes, but they are a special category. So the act of criminalization at an international level has been very restricted. And there you have an agreement among states that those acts by their very nature invite international attention. So I think that specification was extremely helpful, and it helped to develop consensus around R2P. I also think the strong articulation of prevention was positive, even though it was part of the original ICISS report. If you look at paragraph 138, people forget this, but it commits states to the prevention of these crimes, including their incitement. It's very specific language. And so I think that precision has been helpful in terms of institutional development and the work of civil society. I think where two of the major differences are, of course, that the original ICISS report talked about the Security Council being the desired body to authorize the use of force, but that there should be alternatives considered, which of course had been the huge controversy that surrounded the Kosovo intervention about whether another body without council authorization could legitimately intervene. And so the Summit Outcome document is very clear on this, that if the use of force is to be used, it is within the existing collective security provisions of the Charter, with the Security Council at the front of that. That has had good and bad effects. So that's a major difference. The other is, and here I think, again, there is a significant difference, is on this notion of assisting states that are under stress, that the responsibility to protect should be sovereignty enhancing rather than sovereignty undermining. Now, I think you can argue that that original idea appears at times in the ICISS report, but the it's hard to say, can I just say ICIS? The ICIS report is much more infused with the spirit of human security and with more cosmopolitan principles. And 2005 evinces a much, when you really read it and you read the diplomacy, you see this notion that there should be action taken to support states under stress. And this, of course, is carried forward in the diplomacy we see now. When R2P is discussed in the General Assembly, there was a lot of emphasis around the need to recognize national paths to development, to assist states in building up their capacity, all those elements that I hint at and develop in the presentation and develop in the chapter.
Terrific. We're running out of time, but I'm going to try to squeeze one more question in. I'm going to combine a couple, which go to this question of having established the principle of R2P, when are states obliged to apply it or invoke it, or that, to what extent is, for example, the present events in Myanmar qualify as something that should lead to the invocation of R2P? Or Paul Meyer asks, what is the significance of certain states judging internal repression in Myanmar and China as genocide? Does this require any specific action on the part of these states, and how does R2P play into it?
Great question. So, as I suggested to you, R2P was explicitly designed as a political principle. And that means it didn't create any new legal obligations. That's my interpretation. I know some contest it, but I think that is a view that is shared by several, that it doesn't create new legal obligations. It's more an authoritative interpretation, because I think we can take General Assembly statements as authoritative interpretations. Resolutions in and of themselves aren't sources of new law, of what existing law requires. I think with respect to the Genocide Convention, if you look at Article 8, it does, so there are obligations on states to prevent and punish genocide. And those also in the Bosnia-Serbia case of the International Court of Justice are spelled out even further. So particular states have, according to that judgment, also particular responsibilities to prevent and punish. But my reading of the Genocide Convention, and I know there are lawyers present, so they may contest what I'm about to say, is there too. I mean, there is a call to use the organs of the United Nations. There is not an automatic license to use any form of military force to respond. So this is why I describe this, and it will not be enough for many observers. What I like to describe this as is a duty of conduct. It's a duty to consider in an international forum when a situation is deemed to feature atrocity crimes, and then to deliberate on forms of response. What you have seen in addition to that are efforts such as attempts to restrain the use of the veto, which I'll be the first to say, I don't think will affect the behavior of certain members of the council, and I have no illusions about that. But they are designed to try to strengthen that duty of conduct, to say, let's try to create increase the political costs of inaction. So I think for me, that's how I interpret those. Of course, the other thing that these situations such as Myanmar give states, and we saw this with the Gambia, is the right to think about forms of universal jurisdiction. And the case at the ICJ that the Gambia brought, a third-party state nowhere near the vicinity, to taking steps to bring that case to the ICJ, is an example of what the depiction of a situation like this as genocide can actually enable. And so I think that's important for us to keep in mind.
Thank you very much. And in fact, we're exactly at time. So thank you so much for joining us today, Professor Welsh, and thank you for talking about your new book project. We're looking forward to seeing it published, hopefully soon. And I really appreciate you sharing your research and your findings with us today.
Great to be with you. Thanks for the great questions.